And that's kind of my point. We use these legal terms, and we expect the jury to understand it, and they don't. You have to break it down to them. I show them what a jury instruction is. I explain to them what it does.
All right. Part 16 will now go back to order. I do, Your Honor. Please be seated.
And those are start times.
All right.
Just so you know, like tomorrow, 1:30, Thursday, 10:30, Friday, 9 o'clock. Yes, sir.
Your Honor, is there anything we can do about Thursday at 10:30? I've been trying my hardest to get a hearing in front of Judge Denton right next door moved, but the judge.
What time is it?
It starts at 9, but then we got notice today that our hearing won't start until 10:30.
Okay.
His calendar starts at 9.
I
And our
understand.
hearing will start at 10:30.
What does that have to start at 1 o'clock or 1:30, I guess?
I apologize, Your Honor.
That's okay.
So Thursday is now 1 o'clock?
Yeah, Thursday's now, let me see here, afternoon startings. We'll make it 1:15, Thursday. I'm glad we handed this start time out.
Yes, indeed.
That's the 7th? Mr. Parker?
Yes,
7.
that is. Thank you.
Thank you.
Okay. Okay, Mr. Robbins, sir.
Yeah, Judge, I just want to let you know I'm still out there with Mr. Neale.
Oh, now you guys are working out there. I
Thank you, Your Honor. I always say I hope to be brief, and then sometimes I.
You know how that goes.
I'm not. But I will say that, much like the clerk, I thought this was submitted, so this morning I found out it was not. But we have briefed this, like Mr. Parker stated, extensively. There's 6 pleadings for this motion, and I would ask the court, because I know the court, at least prior to this, when you thought we were going to rule on this, had already prepared. And the timelines, the explanation, Mr. Parker says there's no explanation for this. It's all in there. That's why I was willing to submit. But I will briefly kind of go through the timeline to kind of explain to the court what happened. And I appreciate Mr. Parker not throwing me under the bus saying that I purposely didn't do something, but he did throw my client under the bus, and I don't know if they're listening.
Well, we know this. That's all fair in love and war. Right?
Yeah.
So you're right.
But I'm going to
Not the lawyers.
It's absolutely fair. But I'm going to stand up for my client and say they didn't do anything nefarious either. So
I understand.
there was no whiting out of anything or any of this preposterous behavior. It's really a factor of timing, the timing of all this, and then we're in this compressed timing with the expedited trial date and expedited discovery, which we have to abide by. I'm not saying that's an excuse, but it all kind of happened all at the same time. So I'm just going to give you a brief rundown. So we did, and I think it was 2021, do our initial 16.1, and we did initial discovery responses in summer of initial responses to their plaintiff's discovery in 2022 and summer of 2022. And then there was the letter from Mr. Kemp stating that, hey, he didn't think our discovery responses were sufficient. Now, I want to point out to the court, there's nothing in those initial discovery questions from plaintiffs that talks about any of the emails from Real Water to Milwaukee. It was all centered at that time on correspondence between Milwaukee and Hannah, because at least it's my impression when you read their discovery, when you look at the initial motion to strike, the meeting conferred letters, all those documents which are included in our briefs, the sole focus at that time, and things change. We weren't talking about hydrazine then, so obviously things change as things develop. But at that time, Milwaukee's impression, and that's through counsel, through me, was that they were trying to establish a link between our meter, the meters that they had found at Real Water, and buying them from us. They were trying to get that chain of custody showing that they bought the meters from us and not some other vendor on Amazon. So there's a lot of talk about serial numbers and invoicing. POs, that type of stuff. So that's what we were trying to get, okay? So they did not agree that our initial response was sufficient. So Mr. Kemp wrote a letter and came up on the special master agenda beginning in November of 2022. Special Master Hale instructed us to have a meet and confer on it, which I agreed to do, and we did that a few days later in November, early November. And to be honest with you, it was very cordial. I've never dealt with Mr. Kemp before, but it was very cordial. I didn't think 10 years was relevant to stuff, but in the end, he made an argument. I thought about what Your Honor would do if I were in front of you, and I said, okay, you know what, I'm going to produce this and that and the other. Now, this is, keep in mind the timing, Your Honor, so this is November, beginning of November 2022. What I didn't know when I had this meet and confer with Mr. Kemp was the condition of Mr. Brown, because not even the client, which is basically the secretary at this point that I'm talking to, is disclosing his health conditions to me in any significant manner over the phone, which, you know, is understandable. They're not releasing his medical condition, but, and I don't want to get into it because it is a public hearing, but, you know, he had a very, Mr. Brown has a very severely compromised immune system due to events in his childhood. I'll just leave it at that. Unfortunately, what I did not know at this time was that in beginning of September, Mr. Brown started getting very sick from COVID. He was hospitalized in October. Okay? He went into a coma for weeks. When he eventually came out of the coma, it was, I want to say, mid-November. He was sent to a rehab facility for another month. He was spent in there. And he was discharged sometime mid-December. And he tried to return when, and by the way, during this time I'm being told, oh, he's going to come back to work, he's going to come back to work, he's going to come back to work. So I'm constantly updating Camp Jones through emails saying,
and Mr. Robbins, I don't mind telling you that. I mean, health concerns happen. I understand.
okay.
So you don't need to really go into great detail
I
on that.
I need to get to the timing, and I'll speed it up so Your Honor gets that, so I won't belabor it, but I do want to get to the timing because it's relevant. When we get to the deposition, you know, the real point of this motion, Mr. Parker brought up here at the last second, it's these two emails. Actually, it's just the second email. They really want that out. And that's really the whole, and I'm going to state before I get going too far, and we stated it in our supplemental opposition, that this was originally filed in January because they didn't think Jason Brown was really sick. I mean, that's the only explanation I can put up for the vile language that was put in that motion that and I'm going to maybe get it wrong, but I believe they called it laughable. I'm not going to get into it because since then we've sort of patched things up. I want to keep going in that regard, but I don't think they believed what was happening. And, you know, and I get it because I'm calling up the day before a depot saying, hey, he's still not here. Or the day before the discovery was due, according to the special master, and say, hey, he's still not here. But that's because that's the information I'm getting. It wasn't until sometime mid to late December that I started figuring out that Mr. Brown was really sick, really, really sick. And that he had tried, in fact, I had found out at that point on December 19th, I believe, he tried to come back to work after exiting the rehab facility. He made it a couple hours, got sick again. So basically, under doctor's orders, he was told not to return to work until February 1st. In the meantime, through January, I get the motion to strike because it's laughable that this is happening. I'm getting I'm sending letters saying, hey, he's really sick, he's really sick. They keep saying, we don't care, we're going to take his depot. And let me address the depot. I'm sure Mr. Parker did not intend this when he said, well, you know, you could have got somebody else other than Jason Brown to take that deposition. You could have got Carl Salvaggio. Well, the fact of the matter is it wasn't a 30B6 deposition. Okay, and I argued this in the managing speaking agent motion, and I said, you know, they didn't give us any topics. They didn't have time to prepare. It was just for Jason Brown. There were no topics to prepare on. They knew that this email, and I'll get to the email in a second, to Mike Bush, that only the first page of it had been produced, and I can give the court an explanation of how that happened. But it was not a 30B6, so I couldn't substitute. They only wanted Jason Brown. They didn't want Carl Salvaggio. And I'm going to backtrack a little bit, too. At this time, I had received an email. It was an email from not Mr. Rasmussen, but prior counsel for Hannah. And that was in October. Okay, so this was even before the meet and confer. saying that I had no access to, because on behalf of Milwaukee, Your Honor, I tried to get Hannah involved because they weren't involved in all these cases. I don't remember if they were involved in Gallagher, but there's 20 some odd cases. I tried to get them involved in all the cases. I really did. Just to get more insurance available to try and resolve this one. And because I did that, Hannah took the position that we were adversarial and that I had no access to their employee, Mr. Savage. So I didn't have access to him, even though I think he had helped us initially prepare stuff. I had no access to him. I had a letter from counsel saying you are not to contact him, period, until this is resolved. And notwithstanding, I told him, hey, look, once you guys are involved in all these cases, I have no need to go forward with the indemnity. I just need it from you. So now we're into December, and I'm starting to resolve. We get all the way up to these deposition dates that were set. A couple times in January, I had to run the special master Hal. He said, work it out. I said, hey, they're not working it out. I can't even get a return phone call. I'm trying to explain to everybody this dude's really sick. And he's supposed to come back to work in February, and we moved the depot then. So eventually the depots were canceled by Mr. Hale. And then they would unilaterally send them a week later, and I had to go back and do it again. So at this time, this is when I'm trying to get the client to respond to discovery. At this time, mid-January, the issues regarding
we're mid-January 2023.
2023. So I'm resolving the issue with access to Mr. Salvaggio. I do get access to him mid-February, and this is before Jason Brown's depot goes forward on beginning of February. I think it's the 3rd of February. So, and we put in there in our oppositions, Your Honor, all the dates where we produced, 4 or 5 different documents in mid-January before this deposition. In fact, we got a discovery request, supplemental discovery request from plaintiffs on January 29th. I even turned those around before the February 3rd deposition, trying to get them everything. Now, keep in mind, I didn't know that this email to Mr. Bush was going to be an issue. And I would tell the reason I asked for what page Mr. Parker was looking on. So if you look at their supplemental brief, page 3.
Wait, let me follow you.
Okay. This will make more sense when I show you the pictures, but.
Okay, page 3 of this.
Page 3. It should be a picture of page for the page we produced, Milwaukee 192. A lot of paperwork in there.
Oh, it is. All right.
Did you get there?
Yes.
You're looking at Milwaukee 192?
Yes.
Okay. Look, if you look up at the top of that page that they shopped in, okay, it's folded, right? This isn't an electronic copy. So this is how I'm going to explain to you what happened. Like I said, when we got access to Mr. Salvaggio again after the meet and confer, and a little bit to Mr. Brown, to be honest, too. I think I was able to have like a 20-minute conversation with the phone. He said Carl was doing it. So I do think Carl was making these copies. So the way that Milwaukee, so again, what we're trying to do is comply with what we thought plaintiffs were having trouble with, which was the discovery responses, which centered around communications between Milwaukee and Hannah and the invoicing for these meters. So what we asked the client to produce, and I think they'd already produced maybe the invoices, was the PO or the order, anything that had to do with the ordering of these meters. And the way Milwaukee stores these things, Your Honor, is when somebody like Real Water wants to order something, they tell them to just send an email, okay? And so if you look on Milwaukee 192, there's the email on there at the very top or somewhere in there about ordering 10 meters. 192. So it's right at the top. At 4:12 p.m. we would like to order 10 meters. So the way they store these documents, and I hate to flip you around, but I'll just show you if you don't want to flip it around. So this is our supplement, okay? Supplemental opposition. This is Exhibit U, which is Mr. Brown's declaration and some exhibits attached to it, okay? So this is, in fact, this is in fact how they kept their invoices. Okay, they're not kept electronically. What happens is when we'll just use Real Water because that's the most relevant. When they order those 10 meters, they just print the page that it has on that email. So they stored that email that was produced. This Milwaukee 192 was not being produced for communication purposes. It was being produced because it was the purchase order. And what they do is they print that out, that single page that has the order, and they attach it to an invoice. And that invoice and the purchase order go in these folders, these file folders that are kept in boxes. And so when we ask the client, hey, we need you to get this stuff. I mean, we're facing a motion to strike. We got to get this stuff. They're hounding us for Jason Brown's deposition. I need you to get me those purchase orders and those invoices showing, that they purchased this meter from us. So they produced that, okay? And what they did produce was this first page, 192. Now, I didn't know that there was a second page to it. I know Jason Brown didn't know it. I know Carl Salvaggio didn't know it because they didn't go look for the electronic files at that point. They had just went to their folders that have the POs, which is the email, and the invoices attached. So the invoices had already been attached, had already been produced. So they produced these, and they had these clearly prior to this deposition, and they could have called me up because they put it in their exhibit binder. So they knew that they somehow knew that there was more to this email. And I didn't know that. The client didn't know that. We hadn't gotten that far yet because we were rushing to get to this deposition. So there's nothing nefarious going on. That's why it was produced in the manner it was produced, because it wasn't a communication electronically searched at that point. All that was the PO. That's how they kept their POs, is by email. And that's it. So that's why it was produced in the manner it was. Nobody was hiding it. And in fact, when Mr. Kemp did bring it up during the deposition, he said, hey, look at this document. And so I don't know whether Mr. Kemp requested or Mr. Brown offered. He was sitting at his desk and he said, well, I can pull it up. And he pulled it up. And during the deposition, they pulled it up and he said, oh yeah, there's more to it. There's a chain to it. I said, okay. So they went through the entire chain. They did discuss it. And it was a topic of how many pages during that deposition. But they did get an opportunity to examine on that. They were asked to take another deposition of them again. But it was discussed. So, and it was produced. After that, they sent a request saying, produce the entire email chain from that email that was discussed in the depot. And we produced that, I want to say beginning of March 3rd or something like that. So that was produced. So they had the whole email chain. Now, unbeknownst to anybody, so after this, so we get through the depot. I tell the client, hey, out of abundance of caution, let's go back. Now, keep in mind, Real Water didn't sue me. We were talking about a batch mostly at that point. Hydrazine was still not an issue that I'd ever heard of. But so things change as the case goes on. But I said, go back and let's see if there's any other emails like the Bush email to Real Water employees that we had the names of at that time. So they went back and did a search, and they found another Mike Bush email, which is what Mr. Parker held up, which is exactly from the same day. But guess what? It's not the same email chain. What Jason Brown did so he sends this email saying, and I'm just going to point it out to you. So 192, where they talk about the negative ORP instructions using the MA 9025 kit. Okay. And Mr. Brown showed you his deposition and said, well, I made a mistake because I thought they had the MA 9025 kit, which they did. We found it in the facilities, and that'll be an exhibit in this case. So he wasn't actually mistaken. He thought they had the MA 9025 kit. They did. But, so that email's at 11:53 on the 22nd, February 22nd, 2019. And it looks like, and this is Exhibit U.7 to my supplement. He sends the second email, and this is at 11:55. So it literally is 2 minutes later. But he doesn't tag it to this particular email chain. He goes back to Mr. Bush's initial email, and he pulls it up again, and he starts a second chain, which is why it didn't come up during the deposition. And we didn't know about it. Because it wasn't a 30B6. We could have prepared on this. We could have looked for it. They seemed to know about it, but they didn't want to give him notice. So 2 minutes later, he writes back, and he says in a different email chain, but still to Mr. Bush's inquiry, please note the MA9025 is no longer available. We now recommend customers testing negative orb to have their probe tips soaked in white distilled vinegar a minimum of 3 to 4 days to oxidize the probe. When the customer is not using the probe, it is advised to keep the probe stored in white distilled vinegar at all times. So, had we known this existed and had been looking for it, again, that they had not asked for any correspondence between Milwaukee and Real Water, and we were looking at this motion to strike. We're looking at their discovery. None of it pertains to that. Now, we have an obligation to try to produce anything relevant under 16.1. We acknowledge that. And we were trying to do things in order. So this came up secondary to the stuff we thought they needed for the deposition of Mr. Brown, because they insisted on taking this deposition as soon as they could. And so, that's the timing of how all this came about. The problem with this email that they don't like, Your Honor, is Mr. Kemp and taking the deposition.
I don't know if they don't like it. I think
they don't like it.
You don't think so?
Yeah, this is the whole point of the motion. This is the whole point of the supplemental motion.
I think they like. I mean, it really goes to the heart of the consumer expectation test and whether or not the warnings were sufficient in this case regarding usage of the meters.
Well, it
That's kinda
has nothing to do with what was on the box, but if these instructions were given to them, and here's the problem. Mr. Bush testified that, hey, had they told me, after Mr. Kemp asked him 4 times, he said, hey, if they had told me to put it in vinegar, I would have put it in vinegar. Well, we did tell him to put it in vinegar. He just didn't remember it. So that's why they don't like it.
Maybe that's why it's important to have instructions with every unit that's sold, right? And the reason why I say that is this. I mean, I listened to Mr. Rasmussen's argument last week, and I thought about it. That's why there's instructions with every product. That kind of goes to the core of the consumer expectation test as it relates to the restatement of torts 402A, and specifically dealing with products liability, i.e. adequacy of warnings and the like. Because, and here's my point. Say you make a product 1 year and you give a warning, you stop making that product, but you're still making something similar, and the next year you don't give a warning. It's not an excuse to say, look, well, we gave them a warning last time, but each time. You see where I'm going on that,
Yeah,
right?
I see where you're going. But Your Honor, it's probably just because we haven't got into the weeds on this yet. There's a tip sheet with each product, and it tells you to store it in vinegar. So all these new 10 that they bought, they all have a tip sheet in them. They all explain it. So it was there. We can let the jury decide whether it was adequate or not. Let the experts opine on that. But just so I can make it clear to the court that I'm addressing your issue, there is a warning in the box with these meters. Okay? And it's actually a bright yellow, big black, bold font. It's fairly conspicuous, to say the least. So, but I just want to get across to the court that nobody was trying to hide this stuff. Nobody's trying to do it. It's actually beneficial to us. The client ultimately produced it to us along with a whole bunch of other documents that needed to be redacted. Once we get all that through, it was a bunch of customer information. It was all produced. It was produced 3 weeks to a month before the discovery cutoff. Now, keep in mind during this time, they did notice my P&K deposition, and the entire subject matter, I don't want to say entire, but the bulk of it was this second email that I just told you about the vinegar, about why we did this and why we hid it and why we did, there's 17 different categories in there about why we did something nefarious when we didn't. I could have easily explained it to them if they bothered to call me up on it. Probably could have avoided a P&K deposition. And that P&K deposition has been continued numerous times. So when you talk about whether they've been prejudiced or not, if that was a topic you wanted to talk about, all you do is take the P&K deposition of of Milwaukee, but they chose not to. They continued it multiple times, some on our request, some of their requests, but it got continued multiple times, much like this hearing, Your Honor. Multiple times this thing got continued. And ultimately, they decided not to take the PMK deposition. Why? Because they got what they wanted, which was an order on the eliminating motions declaring Mr. Brown a managing speaking agent for the company. So they didn't need it. So basically, they did an end around of PMK by not giving notice on the topic of these emails, which we could have prepared. We could have found stuff. They didn't want to do that. They wanted to take his deposition without the benefit of him preparing. 2 days after he returns to work from being out for 4 months, almost dying, and and then coming to the court and say they're prejudiced. No, I don't think they're prejudiced. They knew what they were doing, and they could have remedied this. I don't know how many times throughout this case. And with regard to expert reports and all that, hydrazine is not even really a big issue in any of the expert reports, even up to the rebuttal, because the Eurofins testing wasn't done until a couple of weeks before the rebuttal reports. So things change, and when you ask the court for an expedited trial date and expedited discovery, everybody's got to comply with that. But certain things are going to happen. You're going to rush depositions. You're going to take Mr. Bush's depo probably before you otherwise needed to. And yes, this came up a few weeks afterwards. This other email shows up. But the real question is, why didn't Mr. Bush tell the truth? And why did Mr. Kemp keep pushing this dialogue that you would have complied if you'd have got notice? I guess the answer is no. We didn't have the emails, and nobody really remembers this stuff because it was such a small issue to everybody back in 2019. Nobody probably really remembers it, and I think that's the truth. I don't think anybody's lying. But the bottom line is there were other alternatives. After this was produced, weeks before discovery cutoff, if you wanted to retake the deposition of Mr. Bush, you could have asked for that. You could have called me up. I would have said, yeah, I'll allow that, and I'll pay for it. They didn't do that. They didn't want to do that. They didn't even file this issue as a eliminate motion. They tagged it onto this motion because they missed the eliminate date. So this is kind of an afterthought for them, I think, Your Honor. And
what about the policies, insurance policies?
Oh, insurance policy, sure. I'll address that. I don't even understand that argument. So initially we produced the 2020 policy. That was part of our initial production because when I read the complaint, that's what I asked for. It looked like a bad batch. We're talking about a bad batch. Now, I think it's fair to them to say that there were other plaintiffs in there and they listed the dates. That didn't grab my attention, Your Honor. So my initial production was for the 2020 policy, and I went and got that and I produced it. And then we had the meet and confer where he wanted all these other policies. And I said, okay, well, I'll get what policies I can get. So then we went back to the broker. I talked to Mr. Brown. I talked to the broker. I said, I need every policy. And, quite frankly, the more policies, the better for me. Please give me every policy.
No, I understand that. More the
I
better.
have no desire to hold policies back. So I produced them. And those were produced January, February, March, somewhere like that. They were produced. They might have been produced mid-January, I think. If I'm wrong, it wasn't any later than the beginning of March. But they were all produced. And not only did I produce them, Your Honor, I produced the name of our broker, their phone number, their address, who I had spoken to, and they said, these are all the policies. There are no other policies. There's no SID policy naming anybody. There's none of this. And she didn't have it. She was the broker for Milwaukee, which is different from a broker for Hannah. She was just the Milwaukee broker, and this was all the policies she had. So I produced them. And I produced them from 2016 up to 2022, however many years that is. So I produced them. They have them. They keep saying, I heard SID today. There's no SID policy. I gave you access to the broker. To my knowledge, they actually spoke to the broker. So I don't know what else to do. I can't produce something that doesn't exist. So I don't know whether SID has any insurance. I have no idea. I certainly don't represent SID. Jason Brown had no access to it. They gave me contact to the broker. The broker is presumably the one that knows their entire insurance policy or picture. I gave them access to them after producing all the documents. So I'm not hiding anything. To this day, and I will say this, I finished the trial on May 22nd. I know that because it's my birthday. The next day, an associate, Brianna, from Mr. Kemp's office, came to my office to review financial records for Milwaukee that we thought were confidential. So, and while she was there, I asked her, I said, do you know something I don't know? Because I've produced everything I can find with regard to the insurance. And she said, I don't know, I checked. And we didn't hear anything for a couple of days, so we wrote a letter on May 25th, an email, saying, hey, we think we've produced all this stuff. It's all there now. Can you please take this, motion that you filed back in January when you thought I was lying about Mr. Brown's illness? Can you please take this off or tell me what it is I'm missing? Okay? So this is in May. This is May 25th, so still before discovery cutoff. And no response to that. So I don't have an SID policy. I don't have control over a SID policy. I don't think one exists, but if it does, I have no idea where it's at. Neither is my broker, my client's broker. So we produced all the insurance, including excess, which they were aware about, and I won't get into the mediation, but we mediated this matter. They had a complete picture of the insurance, I guess, except for this SID, which we don't have any evidence that it exists. So they're sitting here telling you, I should have produced something that I've asked over and over and over, and nobody has it. There is no such thing. At least that's what I'm told. And I gave them access to the broker, direct access, so that they could find out for themselves. They're hearing they should have heard what I heard. So if they heard something different, they should have brought that to my attention. They should have brought it to the special master of the court, and we could have had a hearing on it. Long time ago, not the day before trial. So that's the insurance, that's the emails and how we got to the emails. I encourage you to look. I know it's a lot of paperwork here on it, but look at in our supplemental opposition, if you want to take time to look at this, if you need more time, look at Jason Brown's declaration, look at the pictures. Exhibit U to the supplement. It explains everything with regard to those emails. Nobody lined anything out. The only ones that apparently knew that was an incomplete email was the Kemp Jones firm when they took Mr. Brown's depo. All you had to do was call me up and say, hey, we think a page of this is missing, and I would have had him look right then and there. We would have moved that up to the priority list and did it. So, yes, we have obligations to produce this stuff independently, notwithstanding what they're asking for. But you got to put yourself back into our shoes at that time frame, Your Honor, and we're trying, after the meeting conferred, after the motion to strike, before this deposition, we're trying to find what it is that's the most relevant, because I just had access to Mr. Brown directly in person for about a few hours before that deposition on the day before. I did start to get access to Mr. Salvaggio before Mr. Brown returned back to work, so I'm going to say mid-January, which is how we were able to produce those 3 or 4 different supplements. That's how I was able to respond to even the January 28th, 29th supplemental discovery and turn that around in 2 days. That was Mr. Salvaggio helping me with that. So I did finally gain access to him. He was denied to me, whether it's right or wrong, I don't really know. I know when I'm told by counsel not to talk to somebody's client, I don't violate the rules. Although I continued to talk to counsel to say, hey, I think this is unnecessary, this and that. And it ultimately was worked out before that deposition, and we were able to produce quite a few documents before that deposition. This email, not understanding that the email that was produced is actually considered by Milwaukee to be a PO, and that's the only thing they keep in their paper file. And that's why it was produced. It was produced because in Milwaukee's eyes, it's a PO. It's not a email. That's not how it was produced. It wasn't searched through the emails until a few weeks after his deposition. I certainly would have allowed another deposition on that issue. And like I said, in terms of prejudice, they could have asked me to take Mr. Bush's depo again. Some of them, like Mr. Desitel, he was back in December, so it was before all this. Because all of us were, taking multiple depots a day during this time period. So we were doing our best to try and get this in. The client did nothing nefarious. And it's not just me. I didn't do anything, which Mr. Parker kept pointing out. But the implication is the client did. The client did not. So the client was trying to comply as well. We got it out as fast as we could when we found it, or they found it. We produced it. They had it. There were lots of alternatives up until the day before trial where we could have fashioned something that made sense for them. And I think even in our supplemental opposition, I said, hey, if their warnings expert for some reason needs that document, he wants to opine on it, that's fine. He's welcome to. And maybe that's the solution Your Honor would like to select. I mean, you know how I am, and I know you are the same way, Your Honor. You like to try stuff on the merits. That's the best way to get to the truth. And the truth of the matter is that they were told to use the vinegar. Mr. Bush lied in his deposition. Or I don't want to say lied. That's strong. He misstated himself. I'll just put it that way. And those are the facts of the case. There's 20 other cases out there where this fact's going to come out.
Yeah, we had a case went to trial about 2 months ago, and witness admitted they lied in a deposition. It didn't go very well.
I don't think he lied. I think
it really didn't. It didn't go well at all.
I mean, honestly, do I think that Mr. Bush remembers this 2019 email? No. Did I think, the way the question was asked in the deposition encouraged that response? I think it did. But it's too strong to say he lied, Your Honor. He lied. But anyways, I mean, we're willing. Mr. Moxley, who's their warnings expert, needs to talk about that email. We're okay with that, but they could have filed a supplemental report. Like I said, this didn't even come up in an eliminate motion, Your Honor. This is like tagged on at the last second. So because they don't like that email, they're probably preparing for trial, and they're like, "Geez, I don't like that email." So, there were lots of other ways we could have resolved this issue. We could have had this hearing, I don't know how many numerous times. Your Honor, at one point said you were ready to rule on it at one point even. So, and also the PMK deposition. You could have taken that. You could have retaken Jason Brown's depo. We could have negotiated whether we pay for that or not. Probably would have agreed to it. If not, the court probably would have ordered it anyways. There's lots of ways they could have resolved this, but they wanted this issue to come out. And they knew if they'd taken any of those other avenues, that it would have worked itself out, and they couldn't come here the day before we start picking a jury and try and get Your Honor to throw this evidence out. And this should be tried on the merits. This email existed. Nobody did anything nefarious to prejudice them. And even if you want to say that there's still some prejudice, they could have remedied that prejudice, and they chose not to. This was not produced after discovery cutoff. This was still produced before discovery cutoff. So you still could have resolved it. You could have asked for a supplemental expert report so your expert could consider it. I would have agreed to that. Your Honor knows me. I'm reasonable. And I try all these cases on the merits, or at least I try to. And we would have fashioned something out. But, this seems like, coordinated prejudice, if you ask me. It's not actual prejudice. I think they wanted to come in here to Your Honor and see if they can talk to Your Honor and determine these emails out. Because that's really the real point of this question. And I have nothing else unless you have any questions for me.
And then at this time, sir. Thank you.
Your Honor, if you could you please turn to supplemental motion to strike Milwaukee Instruments answer dated August 2nd, 2023, and go to page 3, if you could.
Yes, sir.
And if you could, Your Honor, could you take a look at the handout I provided the court, date stamped MILW003649.
I think I have it right here.
And certainly, if you look at lines 24 through 26, you see the missing information, correct?
Yes.
Now, Mr. Robbins tries to explain the missing language by suggesting a few things. Number one, that Mr. Carl Savaggio simply missed it because he believed it pertained to an purchase order versus the main defense, MI's main defense in this case, that there is no warning issue in terms of calibration, there's no instructions or inadequate instructions in terms of calibration. That's what Mr. Robbins would have his court believe. That's the position he's advancing. And to further support his position, he called Mr. Bush a liar. He said Mr. Bush lied at his deposition, and then he softened it a little bit towards the end and said maybe he didn't remember when he was being deposed about an email from 2019. And then he further supports it or tries to support his position by saying Mr. Jason Brown also is so sick that he didn't remember these emails. Let's start with the why, and then we'll get to how those positions can't support his request to deny this motion. The why is this information simply kills Milwaukee's defense in this case. This is real water, not an unrelated bottling company, but the actual main defendant in this case, his main person asked him, how do we calibrate these meters? Giving an indication that he does not know how to do it. Please tell us how to do it. Now, we know why this information would not be useful for Milwaukee. We know why they would want to not produce this document. So, how do you explain why this information, this harmful information, is not included in their original production? Because we both know under Rule 16.1, and I think Mr. Robbins acknowledged this, that be it a purchase order, or a question regarding calibration, or a question regarding warnings, or a question regarding instructions, it should have been produced October 15, 2021, almost a year and a half prior to us becoming aware of it. Now, Mr. Robbins says, Mr. Bush lied. Now, if that's the case, why would Mr. Bush lie about saying that he would have observed the warnings if he was told what the warnings were or the instructions were? Why would Mr. Brown lie about it? Mr. Brown, in fact, unfortunately,
actually, that goes to the very heart of why you have instructions and warnings as it relates to products.
That's exactly right, Sean. Absolutely. This goes to the heart of the case. Mr. Robbins is in a very unenviable position. He's virtually throwing Mr. Brown under the bus in an attempt to prevent Milwaukee Instruments, from being found at fault and in violation of our rules. And he doesn't mean to do it. He's trying to find a way to save his client from their own misconduct. Bless you, Your Honor. But Carl Salvaggio did not produce the documents. Mr. Jason Brown, when he had an opportunity, back before he got sick, over a year before he got sick, in October 2021, did not produce the documents. You can't blame that on COVID. He wasn't sick at the time. You can't blame it on any confusion caused by the plaintiff's request for production or interrogatories, because 16.1 says without the requirement for a written discovery request, these documents are supposed to be provided. Now, Jason Brown's deposition was first scheduled October 24, 2022 and continued. November 2nd, 2022 continued. December 6, 2022 continued. December 20th, 2022 continued. January 3rd, 2023 continued. January 13th, 2023 continued. Those were all dates that deposition was continued to accommodate Mr. Brown. Your Honor, I take everything Mr. Robbins says at face value. I've known him way too long for him to misrepresent himself to me or to this court. He's not that type of lawyer. But I do know, and he has acknowledged just moments ago, that his client did not comply with Rule 16.1, did not comply with NRCP 34, did not comply with the rules in terms of the deposition, because obviously Mr. Brown knew of information that had not been produced prior to his deposition and had not been produced in the form of 2 supplements leading up to his deposition. And it's my belief, unless I'm mistaken, that Mr. Brown signed the verification form for the answers to interrogatories. Your Honor, there is no way of getting around the violation. So this is what Mr. Robbins does, which is what he should do. He says to the court today, Your Honor, we would offer to allow the experts to reevaluate or be redeposed. They could have taken other lay witnesses after the documents were produced. They could have taken expert depositions after they were produced. They could do supplemental reports. That's not what you're supposed to have to do. When discovery is done in accordance with stated and ordered deadlines, dates and deadlines, you're not required to expend that additional resource or resources to take additional depositions because someone has violated the rules. Extra depositions, extra reports, extra disclosures, all of those things cost money and time. And had Milwaukee Instruments comply with Rule 16.1 over a year and a half ago, none of those things would have been necessitated. Cleaning up a mess by being offered the opportunity to clean up a mess created by Milwaukee Instruments is not a way of avoiding the consequences of their misconduct, Your Honor. That's why the Valley case is so on point here. In that case, the defendant failed to produce and identify the nurses who gave the adverse witness statements regarding one of their employees, and the lawyers failed to provide witness statements that they had taken in their investigation of the incident. In this case, again, Mr. Robbins is not involved, but in terms of the client, Mr. Savaggio, as a president, did not comply with 16.1. He decided to cherry pick documents he would produce and found a way of avoiding producing documents that he knew would be harmful to his case. And if he didn't do it willfully, he did it negligently, and it harmed our client. And I can't see how you can get around it being purposefully when you consider what we found out during the deposition of Mr. Jason Brown versus the documents that have been produced all the way up until his deposition. Again, Mr. Jason Brown was hospitalized from October 4, 2022 to November 18, 2022. His deposition was taken February 3, 2023, roughly 2.5 months later. These documents should have been produced in their entirety. We should have had the opportunity to take his deposition with the benefit of those documents. Our experts should have had all of those documents before their initial disclosures were required, before their rebuttal disclosures, before we took the depositions, before we did the motions in limine. We weren't afforded the benefit of doing that because the documents were produced so late, Your Honor. And then we still don't have a clear understanding. What we have right now is Mr. Robbins' best attempt to explain his client's misconduct. That doesn't work under Rule 16. It simply doesn't. Your Honor, in terms of the insurance, Mr. Robbins may not be aware of the SID insurance policy, but we did see a reference to an additional insured endorsement or certificate between HANA and SID. We still have not seen that certificate. We've not seen that insurance information. That documentation, that certificate or endorsement that's typically an additional insured endorsement should have been produced. We should be able to see that contractual relationship or coverage between HANA, Milwaukee, and SID. And I want to make sure, I know Your Honor brought that up to Mr. Robbins. I wanted to make sure I addressed that head on. The documents disclosed on the day before discovery, Your Honor, and I gave Your Honor the third and fourth supplements by Milwaukee. The third one is dated June 8, 2023 at 2:08 p.m., Your Honor. the day before discovery closed. Plaintiff should not be required to redo its discovery, refocus its experts, resubmit or submit supplemental reports because Milwaukee has failed or chosen to refuse to produce documents required under 16.1. Suggesting that this was simply some confusion on Mr. Salvaggio's part because of documents related to a purchase order versus documents related to oxidation and calibration of the meters makes no sense, Sean. It's simply that explanation falls on its face because all of the documents, regardless of its relationship to a purchase order versus warnings and calibration communication, should have been produced. It's stated in the complaint that this was the issue. So it should have been produced over a year and a half ago, a year and a half before it was discovered, Your Honor. And it's too late to do all the things that Mr.
Well, we're bringing tomorrow afternoon. We're bringing in a panel.
Exactly.
To start jury selection. So, I mean, I get that. I do.
And so, Your Honor, when Mr. Robbins said that this is something we simply brought up at the end to as a throw-in or something like that, Your Honor, I don't know how much more we could have done. We first filed the motion in January. That's after all of the requests for supplementation, the 2.34 letter, the request to special master, the special master having a hearing, the special master issuing an order. We follow up the day after the hearing asking for supplementation by the 29th. The 29th of December comes and goes. We follow up on the day after that. We've done everything. If this was a textbook on how you pursue your discovery rights under Nevada local rules, 8th Judicial District Court rules, and our Nevada rules, we've done everything by the book. And we've given Mr. Robbins' clients every opportunity for extensions to supplement and extensions to or continuances of depositions. And I believe Mr. Robbins agrees that those extensions all occurred. So when you consider everything we've done in accordance with the rules, compared to the violations of the rules committed by Milwaukee Instruments, Your Honor, the appropriate sanctions would be, of course, to, I believe, because I think it is too late for an evidentiary hearing. And you'd have to call Mr. Brown in. You'd have to call Mr. Salvaggio in. We'd have to call their broker in. When you consider all of those things, I think under Bahena and the Clark County School District case, the court is well within its discretion to determine liability under Rule 37 and prevent the use of the documents provided following the deposition of Mr. Brown, Your Honor. Does the court have any questions, Your Honor?
Yeah, I want to make sure the record's clear. Mr. Parker, how do you think your client has been prejudiced as a result of this?
Oh, good question, Your Honor, and I appreciate that. Your Honor, the warnings case, as you know, when you consider C-Ray and its progeny, the consumer expectation, our experts, our warning experts, did not have the benefit of these documents when they were preparing our case and as we were trying to prepare our case in discovery. That's why we started so early. Our efforts in terms of discovery started in June of 2022, over a year ago, trying to get this information. You can understand the benefits of having this information regarding the calibration of the orb meter and the conditioning of those meters and what you use to do so, and the duration. And I'm sure the court recalls the difference in discussions over between Mr. Rasmussen and mainly Mr. Rasmussen, but also to some degree Mr. Robbins versus the deposition testimony we had of Blaine Jones. And the confusion over the length of time, the solution you should use, vinegar versus the oxidation kit, 5 minutes versus 4 or 5 days. All of those things would have been beneficial to our experts. All of those things would have been beneficial to the depositions we needed to take and the ones we did take without the benefit of that information. And to suggest we have time to redo all of those depositions now, most of those witnesses won't be available at trial, Your Honor. Even if we wanted to try to do it at the time of trial, we couldn't. We're stuck in most of these cases with deposition transcripts that we're using. That's why we've submitted to the court, I don't know how many deposition designations we've done already. Dozens, I believe. It is too late to clean it up, and none of our experts have had the benefit of it. And we've not had the benefit of it in terms of questioning any of these witnesses. We simply did not have the benefit of any of these documents. It's too late to do further expert reports. And we can't even do motions in limine or other dispositive motions based on this information. Because we don't have the testimony which would have gone along with all of these late disclosed emails. This goes to the heart of our liability against Hannah and MI. I say MI, but Milwaukee Instruments. And that's why it was withheld by Mr. Salvaggio, their president. And he should bear the brunt of the sanction based on Rule 37. And certainly it fits within the factors under the Young-Rivero case. One is not holding the client responsible for the wrongdoings of the attorney. In this case, it's not Mr. Robbins. Mr. Salvaggio committed the misconduct. And when Mr. Salvaggio decided not to do this, he prevented us from having this case go through discovery on its merits. Because he withheld documents related to the merits of this case. Our claims uniquely were related to, when it comes to Hannah and Milwaukee, to the warnings, the instructions on calibration and observation. There's no way around it. We've been severely prejudiced by this, and there is no explanation as to why that alleviates MI's position. I can't see how they can explain it, Your Honor. I've struggled all weekend in preparing for this to figure out how do you have the subject information, the to and from, the end of the page, and you don't produce what's in the middle, the actual text of the email. And if it was on the following page, as Mr. Robbins suggested, then why would you stop if you see the to and the from and you don't see the content below it? There's just no way of bringing any common sense to the defendant's position, Your Honor. Any further questions, Your Honor?
No. Mr. Robbins, what about my last question regarding prejudice? So if I didn't ask you that, I want to make sure you have an opportunity.
Well, I think I sort of if there's any prejudice, it's manufactured prejudice.
I mean, they say, oh, we couldn't even do a eliminate motion because we didn't have the testimony from this. Well, you could have. You noticed my client's PMK deposition, and the only topics really of substance on there were these emails. Okay, you could have got to that, and you could have filed your eliminate motion. We could have argued that. You didn't want to. Now, this is manufactured.
Well, I want to make sure I understand. Why do you think that these emails hurt the plaintiff's case in chief?
Because it says their whole thing, hey, we wouldn't be here if they didn't desert it. Honestly, why would Mike, I want to defend Mr. Salvaggio a little bit to answer that question. He went to those files that I showed you the pictures of. He didn't read them. He just said, here's all the stuff. Here's the invoice and the PO. The PO is an email. He wasn't reading anything. He's not sorting anything out. And to say that we didn't comply with 16.1, we did. We did our initial productions.
But coming back, why do you think these emails help your client's case?
Oh, because it shows that we did tell, and it's not just this one. We told them in 2017. There's a document that was produced by Real Water that the reference there that they're talking about in that page 192, Milwaukee 192 reference. That was actually given to them back in 2017. That was given to Mr. Desatel at the time, who turned that exact email reference, or I'm not using the right term, web reference, into an email to everybody at Real Water. So, to answer your question specifically, Your Honors, that second email, it's the second email I'm talking about, the one that came 2 minutes later, which is Exhibit U.7. It basically demonstrates that we did tell Real Water to use the vinegar, okay? And they were given the proper instructions. They had them. They had them back in 2017 with regard to MA 9025, And then in 2019, they
When
had
you
it
say
with
MA, whatever was that the
kit. Yeah, the kit.
Okay.
But I'm saying in 2017, it was MA 9025. In 2019, it was vinegar. And he told him that in vinegar. He responds in the email, yeah, it's vinegar. And guess what they were using? I mean, you're going to hear probably from multiple witnesses from Real Water that they were storing it in vinegar, including Casey Aikens. So they did. They got that information. And this email demonstrates that. That's why they don't like it. But it would be a fraud to let the jury think that we didn't tell them that. We wouldn't be trying this case on the merits. And like I said, they had plenty of time. If they'd come to this court and said, hey, we need to retake Mr. Bush and Mr. Desautel's depots, and those are, for all the talk of all the depots, I think those are the two that came up, and my expert needs to do a supplemental report or be allowed to testify to trial. I'd agreed to it.
But do you think that is a defense under the consumer expectation test as it pertains to the warning requirement? And typically the thrust and focus is on the adequacy of the warnings and the product insert on the box, those types of things.
I think that could be up in the air, Your Honor, because and I agree with you. It's a different issue, certainly, with regard to the instructions on the box or in the box.
Right.
But I think it goes to notice as well, though, if these plaintiffs had the correct information and through Blaine Jones, he trained everybody per those instructions, and he got those instructions, then, I think they were following the instructions.
Well, here's the thing. Whether they were following the instructions or not, at the end of the day, isn't the focus is on the adequacy of warnings. And the reason why I say that is this. How many new quart meters did they purchase between, say, 2017 up until this unfortunate event? Because it's my understanding they were producing quite a few per year. Is that correct? Something like that.
I'm sorry, I didn't.
How many were they producing? How many were they purchasing per year? And I don't know if it's
Producing to Real Water? Or?
Yeah, I should say supplying.
Supplying.
Yes, I'm
I
sorry.
don't know, but it's dozens at least.
Right. And so I don't know if it's a defense to sit back and say, well, they knew this or they had the conditioning kit back in 2017. Because it's my understanding under products liability law, when it comes to adequacy of warnings, you should have the proper warnings in each product delivered. And here's my point. I think this is an important point. What happens if you have a new employee that comes in? Right? That's why each product has to have what would be considered adequacy of warnings. So it's not like an institutional warning. Well, we warned them one time and this is their fault. They didn't train. Well, then we're focusing on conduct of parties, and that's not a real defense. We know that. It comes down to the product, whether the product was defective. Pursuant to 402A, we have the consumer expectation test, and we also have requirements as it regards to warnings, product inserts, the boxing, and all that.
If Your Honor wants to limit the testimony to what's on the box or in the box, hey, I'm for that. They're going to jump up behind me and say, no, we want all that MA 9025 stuff from 2017 and the internet. We want all that, and we want all that.
No.
So, but I agree with you, Your Honor. If we want to focus directly on the box, and that's the law, and that's going to be the jury instructions, then none of this stuff is relevant except for what's on the box or in the box.
Well, maybe it's relevant because it may reflect what should have been in the box when it came to conditioning and those types of things.
Well, it was in the box. It was in the kit, and but things change, Your Honor. Too. The instructions change over time. So what was given out in 2017 is not the same as 2019 and maybe not today. I don't know.
Well, but you would hope that the instructions would get safer over time.
Who's to say they didn't? I mean, that's for the jury, Your Honor. That's not for us to decide today.
Well, but I'm trying to understand the position you're taking because at the end of the day, it seems to me whether they were given verbal instructions and or they had the conditioning kit in 2017. Isn't that when they stopped making it, 2017?
End of 2017.
Right, 2017. How was that somehow a defense to products being sold in 2019 that didn't contain the same type of warnings?
I guess that's for the jury to decide, Your Honor.
Well, I understand that, but I'm
Because
just
things in 2017, I'm not the one raising this issue. This is them. They want to bring up this handout, okay, and this first email, and where Jason Brown then says, "Well, I thought you guys had the kit." He says, "I might be mistaken. That might be a mistake on my part." Well, he wasn't. They did have the kit. We found the kit.
right. But how is a kit a defense?
It has its own instructions in it.
Okay, but those same instructions should be in the product you sell after the kit is sold, right?
You read the instructions in the meter along with the instructions in the kit to get together, Your Honor. It says in that there. We didn't brief any of this, but if we want to go into that, that's another 2 hours. But into what instructions were actually given with this meter. There's quite a few of them, and we have an expert that says they're adequate.
Okay,
Now,
but that's a different issue. But for example, I go out and buy a new vehicle today, and it has instructions. We'll say it's electric, how to operate it, how to charge it, how to prevent a fire. Okay, I get that product. Now, if they would have given different warnings 3 years ago regarding what I shouldn't do that could result in a fire, and they stopped doing that, maybe overcharging or whatever, you can't sit back and say, well, we gave them that instruction 3 years ago.
and this is my fault, Your Honor. I'm just not doing a good job explaining this.
I mean, but that's...
Well, we did, Your Honor. It's in the tip card. It's in the box.
But I'm not talking about what's in the box. There's like this fallback that, well, it was in the conditioning kit, right?
Yeah, but the kit ended in 2017, which necessitated the tip card that goes along with the instructions. It's right the first thing you see when you open the box, and it says vinegar. This is how you take care of it.
But you have to remember, I hadn't questioned anything that was contained in the box that was sold to.
No, we haven't got that. It's not even.
No, I haven't even touched that. I mean, it seems like there's.
But I just don't want to leave that impression with Your Honor that somehow Milwaukee or Hannah did not give appropriate instructions. We believe we did, and we have an expert that's going to say so. And that's for the jury to decide when they listen to our
I don't want to cut you off. I agree 100%. That's why I'm not talking about the adequacy of the instructions in the retail boxes that were sold.
Yeah, I don't want to go down that rabbit hole.
No. I'm not even addressing that issue. That'll be for the jury to decide whether the instructions would be adequate or not. I mean, I get that.
The question is, why did we leave this till the day before trial, Your Honor? There's a reason. They manufactured this. They didn't even do it as a limine motion. They didn't take and listen, they're great advocates. Nobody will say otherwise in this room. I guarantee you that. They're great advocates for their clients, but we're just asking the court to see it for what it is. I mean, this was produced weeks, even that. You have, 16.1 is not a one-shot deal. You're supposed to produce everything you think is relevant. Then you have a continuing obligation.
Yeah, continuing obligation
Right.
to seasonably supplement. I think
Right.
that was
So
Commissioner Bigger.
As we're finding these documents, and again, I just wanted to address one other thing, as long as you let me come up here again.
Oh, absolutely.
This talk about, we set his depot in October, November, twice in December. Yeah, he was sick.
I'm not.
Okay, I don't want to address that either.
Yeah, I take that. Some
That was
people
very
die.
magnanimous of you not to take his deposition while he was in a coma or the rehab facility.
Well, my point is, COVID was a serious disease.
Yeah.
It was
You and I
serious.
had a trial during COVID, Your Honor. We know how serious it was, and that was an annoying trial to wear those masks, but we all did.
Yeah, it just was serious, so I don't question that. Let me see anything else I had for you. All right.
Oh, I just wanted to
No, go ahead.
because I know you're going to want to, I don't know if you're going to rule from the bench or you want to look at this more, but I did want to say, Mr. Parker, tried to get back to the SID, and that there's some additional insured endorsement on some HANA policy or something I don't even know what that is. That's HANA. There's nothing with regard to Milwaukee. But like I said, I produced everything for Milwaukee. I gave them complete access to my broker. You're not hearing him get up and say anything about that. I hate to say never, but I don't believe there's any other policies. I think I've produced all of them. And like I sent in our email in May of this year, if there's anything else, let me know that you think that I've not gotten. I will try to get it for you. I get no response to that then. So instead, we want to piggyback on the original January motion to strike because Mr. Brown, wasn't going to be made available for his deposition. Again, not a 30B6, just Brown. They only wanted Brown. I couldn't produce him. I had a medical note. So, but I don't think there's any other documents out there. If there were, if If there's another 20 million in insurance, I'd like to know where it is myself, because I've done every digging I can. The client's done every digging. The broker's done every digging. I don't have anything else. So I think that's just a silly argument. And if they had something, bring it to the court. All he could mention was something from Hannah. I'm not Hannah. So I buy from Hannah, but I'm in North Carolina. So, I don't know of any other insurance. If there was, I would tell Your Honor about it. I would tell counsel about it. I've dug under every rock to find every policy. I can't get blood out of a turnip, Your Honor. If it's not there, it's not there. They're not showing it to you in court that I withheld something. So it doesn't exist. That's my answer. It doesn't exist. I've given you everything. 2016 through 2022, primary and excess. I've given you what the broker has, and that's the broker for this company. She should know the insurance picture. And I gave you access to her. So I really think that that's just kind of a red herring argument. Again, that it's a novel argument that Mr. Brown Mr. Parker came up with over the weekend and wants to emphasize, but we've given him the insurance documents. They've had them for a long time. We've had a mediation on it. They understand my insurance picture better than I do. I mean, that's a true statement, because I'm here to defend the issues and not the insurance. But I understand why it's relevant. I would never try to withhold that stuff, and my client didn't either. We thought in the initial production, 2020 was the issue. And Your Honor and I have had, I don't know how many construction defect cases over the year where that's, which policy is it? I mean, reasonable minds can disagree on that. That's why we had a meet and confer. And unfortunately, that meet and confer occurred at a time when I had no access to the guy that was going to answer my questions. So I didn't even know how to get hold of the broker. Or I didn't figure it out. I guess there were ways maybe I could have figured it out. But ultimately, when I got Mr. Brown back, and contact with Mr. Salvaggio, I got the broker's name and called that person, made sure there was no other policies. Please give me every policy that you have going back to 2016. Please, please, please. If you did that, I produced it. So I don't know what else I can do with regard to insurance. I don't know why that was thrown in here on rebuttal, but I appreciate the opportunity to respond to it. And anything else, Sean?
No, that's it. Thank you, sir.
I just answer a couple of questions asked of Mr. Robbins. Based upon the discovery in this case, between April 28, 2017 and May 19, 2020, we purchased 116 of those meters. And so when you made the point, which I wish I'd raised myself, about the difference between an email instruction versus instructions out of a box, our employees changed.
I mean, Mr. Parker, that goes to the very heart of the consumer expectation test, and one of the three areas upon which potential products liability claims can be based upon. We know you have design defect, we know you have manufacturer defect, and the last one deals specifically with adequacy of warnings and the like. So that's a different issue.
And between March of 2012 through April 2017, we bought 23 of the oxidation kits. Mm-hmm. December of 2017, and Your Honor has a very good recollection, that email, December 7, 2017, sent at 1:01 p.m. from Milwaukee to Jeffrey. Indicates, hi Jeffrey, the MA9025 kit is no longer available because the CE European governing body has ruled that solution number 2, and the kit is so toxic that we can't sell the kit any longer. The U.S. EPA does not have a problem with the chemical number 2 in the kit, but the kit is produced in Europe, so we no longer have it available. Your Honor's recollection of these documents is very good and very to the point in terms of the use of these emails by Milwaukee, and the reason why this information should have been provided under 16.1 and how it should not be used to afford some type of defense or support some kind of defense by Milwaukee, produced on the eve of discovery cutoff after being sworn to in depositions and in answers to written discovery. and the certifications under 16.1 that all documents have been produced. Your Honor, Mr. Robbins is asking you to ignore the misconduct of his client, of his president, Paul Salvaggio, ignore the impact of Rule 16.1, Rule 34, Rule 32, and Special Master Hale's order. And when he said we sprung this up at the end, and we're hearing the last day, we were trying to find a way to resolve these issues since January of 2023 when we first filed the motion. We didn't know that these additional documents would come up during deposition. We didn't know further documents would come up 2 months later. And then finally, on the eve of the discovery cutoff. So when you consider the reasons why this hearing has been delayed as long as it has been, is because the ball kept moving in terms of Milwaukee Instruments discovery abuses. We've tried to provide a chronology of all of those discovery abuses, Your Honor. And certainly when the court considers them in their totality, given the case law cited in our briefs, Your Honor, some form of sanction is required. We're not asking for the answer to be stricken as to the entire case, their entire defense, but we are asking for it in terms of liability. And certainly, I think Mr. Robbins acknowledges that documents submitted on the eve of the discovery cutoff should not be allowed. Thank you, Your Honor.
Thank you.
Your Honor, can we check with Mr. Kemp and Mr. Neale? I know they've been working diligently outside. We may not have to argue the last motion at all, depending on how that discussion turns out.
Yeah, I understand that. And I just have a couple comments because I want to think about this. These are always very difficult issues for me because, I go back and I understand the young factors, right? I do. And Mr. Robinson made one comment that I do believe, and it's the policy favoring adjudication on the merits. I heard that, and he said that. And I do feel that way. I do. And so what I want to do is, I understand the factors, the willfulness of the offending parties, extent to which offending parties would be prejudiced by a lesser sanction, so on and so on. I get it. And any decision I make would be based upon that. I do see the emails or the messages as far as instructions are concerned. I can see where they're potentially germane to the issue of the adequacy of the warnings. I get that. I do. And we discussed as far as strict products liability law, that goes to the third prong or potential claim for relief as it focuses on adequacy of warnings. And the issue here is this. There were questions and or concerns from clients regarding how do you calibrate this product? What do you do? And so on and so on. So that goes to the heart of that. I don't know what I'm going to do with it yet. I don't know. I'm going to think about it. I'll probably issue a decision tomorrow on this issue.
Thank you.
Okay, what's the third issue? Is the second issue resolved, Mr. Kemp?
Judge, we're getting closer, but you think it's probably not worthwhile to argue it. We're going to agree to submit it on the briefs if we don't resolve things.
Okay, how long do you want me to wait before I issue a decision? How much time do you want me to give you? Mr. Neale, what do you think?
Well, Your Honor,
Because I'd rather give you a shot to resolve it, sir. I really and truly would. What do you think, 24 hours?
yes, sir.
I'll do that. So I want to issue a decision before the close of business tomorrow at 5 o'clock. How's that?
Thank you, Your Honor.
I think that's the best way to handle that because I'd rather take an appellate issue off the table if I can.
Your Honor, I
I haven't noticed any so far, Your Honor.
Well, sometimes I have to call them. But, I'd like to give you an opportunity to at least resolve it, because I think you have resolved some issues, right? Yeah, you have. I mean, Mr. Odou, you have resolved a big issue, right?
Moving it along.
Okay. We're not there yet?
We're still working.
Okay. That's all you can do.
Your Honor, I have two matters to address with the court before tomorrow. The first is we are planning to bring some of the physical evidence to court tomorrow morning from the real water facility in Henderson and from the joint storage facility. Some 5-gallon bottles of water and boxes of bottles to be held in evidence. I just wanted to make sure there's no concerns with having that delivered to the court tomorrow in terms of storage or if there's anything particular that we need to be aware of.
How many of them are there? I mean, 5-gallon jugs.
There's, I think, just one 5-gallon jug, and then
Empty or full?
full.
We don't want anybody drinking. There's a warning sign or something.
There's FDA prohibition on that.
And then we have a
We can put it in.
container, a 5-gallon container, empty of the concentrate.
Okay. But they might need the ante room. Who's ante room?
That's all.
What about that room? What? All right. Can't we lock them up back there in the closet? We don't have a, there's no lock on that closet door, Mr. Marshall?
That's correct.
We have to bring it down here.
And are we having admitted into evidence?
Not tomorrow.
It will. Some of it will be admitted. For example, we're bringing the titanium tubes.
Well, we're going to have, from what I gather, and this is the problem. We should probably. Was it Judge Gonzalez had a like a gun safe in her apartment? Remember that green gun safe she had? That's what it was, right? We probably need one in here, but I think you can bring it in. But it's my understanding of talking to staff, we probably have to put it in the ante room and lock and key it, right?
Yes, Your Honor. That would cause for us to have to change the locks. So it would be a controlled room, whereas at this moment it is not controlled access.
We don't have to bring it tomorrow if we'll benefit from additional time. There are logistical issues. I mean, none of it's germane until the time of trial when it's going to be admitted.
I understand.
If that's easier, we can hold off and.
We can put in a work order to have that room rekeyed, and then once it's done, we'll let you know and we can bring it in.
Okay.
Are you trying to admit the full 5-gallon bottle? Or just the other stuff?
I don't know
that we even need to admit it.
I don't know that we'll need
Yeah,
to
I
do
wouldn't
that.
think so. It's just that aren't heavy. And,
I think some things, like the titanium tubes, will need to be admitted.
So are you bringing the meters as well?
Meters, yes.
Okay. We talked about that. I just want to make sure that you're bringing those when you're bringing this other stuff, right?
Yes, everything that either party wants us to bring. It's just the process to go to the facility, get it, bring it here. We didn't want to do that without some understanding of there's going to be a place to store it. It's acceptable to the court for us to do it. And if we need to hold off, that's not an issue.
Once these are admitted, they have to be under lock and key. So if the water jug isn't going to be admitted, then it would be okay. But the other items that you're discussing, depending on how large those are, they have limited space here.
yeah, they're not that large.
Okay, would they fit? Do you think
So a meter in box is this big. It'll be that big.
So you think everything in totality would fit in like one banker's box?
Yes, I think so.
Okay, well then that's why we don't need to change locks.
5 by 8 by 3.
Except for the model.
Once things are admitted, they go under lock and key.
Okay. Yeah, we can hold off and not do it tomorrow. We need to figure out further logistics. The second issue is in terms of the panel of jurors, the 66 that are coming in, that's going to take up all the seats here.
Yeah.
And I know that we have and clients. I know they want to participate and be here for the process as much as they can. I mean, there'll be times where they're unable to because of work or anything, but in terms of space, I just wanted to understand our limitations or restrictions on a given day or our options, I should say.
I think pretty much limited to whatever's outside of the gallery behind you would be the limitation. Because other than that, especially during jury selection, we need every panel member we can get in here.
What do you think is the largest number of people we can have during jury selection?
During jury, 3. That's all you have over there is 3 chairs. Right? What you have there is what we have. That's all we have. During one year, we'll have all 66 of these. And we spoke about this before. Is that after 1 year, I'll reserve this first row on each side for both sets of clients who are coming to observe. But during 1 year, this is it. That's what you have.
If we had 4 or 5, would we be able to move the table and add another chair or 2 here?
So, we'll do the best we can, but I'm worried about, we have a capacity, fire marshal, rules. I want to be as comfortable as I can, but we don't have to.
Do we need our trial consultants during board here?
Do we need what?
Question.
Yes, indeed.
Yeah, you guys.
Do we need
I
what?
don't need yours.
Oh, thank you, Teddy. Appreciate it. Do we need them tomorrow?
Presenters. Yeah. I don't think we need the presenters.
What about a statement from the court, just due to the limited spaces, clients are not in here currently during board here, so nobody's prejudiced by that fact? Would anybody be agreeable to that, or?
We won't bring we have clients, but we won't be bringing them to tomorrow.
Yeah, I mean, I'm less concerned about that. I'm more concerned if they want to be here and just being able to tell them if they're able to, great. If they're not, explaining why. So I don't know that we're going to have more than that.
Here's the issue. My concern is slightly different. And, well, no, that's his concern.
You're right.
My concern is the plaintiffs identifying them, because I'm going to ask, of course, the appropriate question: do the panel members know anybody?
Right.
Right, and that's really kind of important, even from a defense perspective. That's one of the first. Yes, after about 20 minutes or so, I get into that when I start asking questions. Any of the plaintiffs, any of the defendants, any of the lawyers, and so on and so on. And almost every jury trial, it's kind of surprising. Las Vegas, notwithstanding 2.5, 2.7 million people, you'd be shocked at the number of people that might know one of the lawyers or law firms or heard about something. I mean, it just happens. Sometimes they might know one of the parties or one of the witnesses. Because I think what happens when you bring in so many people from a board our perspective, the odds go up that they'll know somebody.
Your Honor, do you anticipate, given the afternoon start tomorrow, that you're going to take up most of that afternoon with your board?
Probably. I don't know if I'll do the whole afternoon, but I'd say probably 2 hours.
2 hours,
maybe a little more. And all I do as far as the jury selection is concerned is essentially this. I try to get them warmed up. I want to make sure they understand why they are here, right? And last but not least, I want to make sure they understand their role, and also they understand what jury instructions are. Very important. It's the law. Because if they can't follow the instructions I give them, I let them go. And I think part of it is education, because law students don't know what jury instructions are. They don't. If somebody graduates from law school, you've never seen jury instructions. Do they talk about jury instructions in law school? They don't, And that's kind of my point. We use these legal terms, and we expect the jury to understand it, and they don't. You have to break it down to them. I show them what a jury instruction is. I explain to them what it does. I actually read the first instruction that deals with the responsibilities of me as a trial judge and what their responsibilities are. And just as important, too, because sometimes you have issues, people wonder about jury nullification and those things. And what I mean by that, some people actually believe, if I don't like the law, I don't have to follow it. And we can't have that, right? But here's the real big issue, and you'll see I'll spend time on this. They have to have confidence that, you know what, we're doing a pretty good job, because I tell them when it comes to law, in a general sense, 90% is agreed upon by the parties, which is true. There might be a few instructions you disagree about, but they have to have confidence that when you read this, that they know this is a law that applies to this specific case, and they got to promise to follow it. If they can't follow it, I'll see you. That's how I like that. Is that important?
Mr. Kemp and I have reached an agreement in principle, Your Honor, that would resolve Mr. Haley and Mr. Belsky's claims against UNFI. We'll reduce the term to a term sheet and endeavor to have that signed before you begin picking the jury for them.
So what does that do to time? Anything?
I think it'll save us a little bit, John.
Yeah. Understand. Well, we'll deal with that. I'm quite sure you get it reduced. Anyway, any other questions?
No, Your Honor.
Because I should be. I would hope. I don't usually take a whole afternoon, do I?
I'd say 2 hours is good.
2 hours.
Yeah, I think that's good.
Judge, you know how many we have coming in tomorrow?
66.
66. Yeah, we got 66 tomorrow, 66 Friday. We're moving.
2 afternoons only, right? Thursday and Friday now? No, Friday's full.
Friday's a full day.
Yeah,
Friday is a full day.
that's right. So do we have 2 different groups coming in on Friday maybe then?
No, just one.
Or 66?
66.
Wednesday at 1:30, Thursday at 1:15, and Friday at 9.
Yeah, but we have 66 panel members. We're not going to have panel members come in on Thursday. We won't go through that. That's what I.
Thank you, Your
Are
Honor.
we done?
Yep. Yeah,
Thank you, Your Honor.
4:27.
Okay. What time tomorrow? 1:30 tomorrow.